interest litigation, which would work towards their sort of supporting the campaigns that they came up with as a movement, and also which would have a clinic where people could come and deal with issues in education in South Africa, which are quite systemic, quite ingrained, and quite problematic. And so we were birthed out of the idea of a very clear understanding of the link between activist lawyering and social mobilization, and that was really how we were birthed. And so because of our activist nature and because of our close links to a social movement, the idea of activism and the legal profession is often something that we grapple with as lawyers. We're a team of young lawyers who have just come out of university, who are younger than 30. And one of the questions that we've been grappling with and asking ourselves at the Law Centre is, what does it mean to be activist? What does it mean when we call ourselves activist lawyers? Is the legal profession and activism, are they compatible? Are they at odds? Is it correct as legal professions that we choose to use activism as our tool and our mode to try and bring about social change in South Africa? And so a group of young lawyers within our organization, who I'd like to name, because a lot of what I'll share today is part of their thinking, Lisa Piliso, Ibrahim Daniels, and Tatiana Kazim, started thinking and researching around this idea of what does it mean to be an activist lawyer. And so that's really what brought about the idea of this roundtable discussion. We were also aware about the tensions and the current debates in the UK around this term and the use of the word activist lawyering, and whether one rejects this, whether social change lawyers think it's a good word. We were quite intrigued by a sort of rejection that we sort of saw, or a sort of uncomfortability or a rejection of the notion that a lawyer could be both a lawyer and activist, and whether the two words together were uncomfortable for lawyers and why, and we found that intriguing. And so that's what brought about, with the support of the Joel Joffe Foundation, the idea that we could meet around a round table and together discuss these tensions, together discuss what does it mean to be a legal profession or a legal scholar, and seek to use the law as a tool for social change while also using activism. Ought we do this? Is it wrong that we do this? Are we watering down either legal scholarship or legal professionalism by doing so? And so those are the questions which we seek to sort of ask ourselves with this roundtable. I suppose in sort of grounding us, I'll start by maybe giving my sort of understanding of what is activism, because we often use the word use loosely. And as we started this work, I realized a lot of us have asked, what is activism? Probably would take some time to actually think about what does it mean and unpack what that means for us. And then to also think about what does it mean when we say a lawyer. So in South Africa, it's a lawyer, here it's a barrister. And so what does that mean, because we use it loosely. And so I then looked at, for example, or the people in our office looked at, for example, the definition which was given in the activist handbook. And some of the main features, there's lots of contentions about what does it mean to be an activist. So even that is a whole debate, and we could have an whole hour debate on what it is to be activist. But it seemed that what was main in a lot of the definitions was the idea that activism is born in a cause. So there is a cause or something that people are fighting for or fighting around. And that activism uses tools which sits, particularly, for example, in a democratic state, which sit outside of the tools that one uses within a democracy. So the idea that it's using other tools like social media or protest in a different way, but using certain tools to try and bring about change for that specific cause. And another thing which a lot of people are starting to accept is that what is crucial to activism is that activism must be grassroots led, or must come from the ground, or must have some sort of element of grassroots. And so for me, the working definition I'll use for my understanding of activism is that activism is about a cause, it's community and or grassroots level and based, it can be any number of people, and that it uses certain tools, tools like mobilizing, tools like disobedience, breaking the law in order to be activist. Some of the ideas, for example, which you get in the activist handbook, some of the tools they list is civil disobedience, cultural activism, digital activism, which we're seeing being used much, much more, and we use a lot, raising awareness, political activists, legal activism. Funny enough, that the handbook on activism lists legal activism as a tool for activism. and financial activism. And then I'll go now. So I've given you my sort of idea and framing of what I understand to be activism. And then the legal profession, for me, what's important about the legal profession and our understanding when we look at the two and whether or not they are compatible is in most jurisdictions, whether South Africa or the UK, we understand that most professions have a sort of ethics and code of conduct and rules that govern how they behave and how they ought to be as lawyers. And what runs through all of us is that this idea of ethics, this idea of honor, which is always followed the law profession, the idea that one must work around and is governed by the rule of law, the constitution in South Africa, principles of idea that one must act in the interest of their client, phrases like protecting the court, working in the interest of the court, and our behavior. And one's behavior as a lawyer has really always been a fixation of what does it mean to be a lawyer. One's behavior has always been at the forefront of that thinking of what does it mean to be a good lawyer. And so that's where I think the convergence and sort of the tensions start coming in on the notions and ideas of thinking about being the legal profession and activism, because one thinks about those issues about protecting the interest of the court, upholding oneself to a good behavior. So if I'm off to go to a march and I strip because I'm in a women's march, have I brought the profession to disrepute? This idea of one bringing the profession to disrepute. Looking at the stuff, your duty to the court, observance of the law, protection of the rule of law. And so when one thinks about this idea of the legal profession and you think about the sort of standards and ethics, already you're sitting in sort of a void which tells you that this notion or this profession is at odds with activism or the vibrancy of activism or some of the tools that activists choose to use. At the Equal Education Law Centre, and so in thinking around this for years, people and lawyers and lawyers who sought to find social justice have grappled with this idea, and out of that has been topics about resistance lawyers. People have spoken about action lawyers. People have spoken about terms like community lawyers and movement lawyers. I won't go into that because we don't have a lot of time, but at the heart of us at EELC is movement lawyering. And the idea of movement lawyering having been birthed out of a movement is the idea which was gone around the criticism of public interest lawyers who were sitting in our own ideating, speaking about theories, looking out of the window at what we perceive to be social ills, looking at the law books and trying to come up with innovative legal solutions, legal arguments and running cases, which often grassroots organizations and movements at the end of these great victories that we would get, report about, learn in law school, often social movements would come back and say, well, I heard you, good you got that victory, but I have no way of articulating what the hell you just did or what this law means. I have no way of actually going and demanding what victory you've just gotten because I don't understand this language and it's all just waffles to me. And actually your victory is actually meaningless and I never got my house or I never got the social, the things that you got. And so out of this sort of thinking and criticism, social movements started saying, well, we must be the ones who tell you what you must go litigate. We must be the one, you must hear from us and you must then litigate with us. You should, so for example, with Equal Education, we can have the General Secretary of Equal Education, which as I said, it's a young movement of learners. They sit with us as lawyers and say, well, we want infrastructure in our schools. And we, in fact, go to meetings with them, with our solicitors, to discuss what do the papers look like. If I win a court victory tomorrow and I get a news agency ask me to speak about it, I won't go to the interview because I can easily say that an 18-year-old learner in a rural area in South Africa is able to go and speak to a newsroom, tell the newsroom what law just got changed, why that law was problematic for their system, and they're able to then hold that law as a power and as a tool. And so in using movement lawyering, our idea at EELC is the idea of one as a lawyer building the power of people and not building the power of the law. But of course, as that's a tool we've used. But as I've said, as we've sat and intellectually tried to debate this use of these tools and whether or not it's compatible with our profession, how far does one go? Is one going too far? Is it a problem? Should the law be changing with times and should the law be activist if we do seek to bring about social change? And so actually that was just saying, and so And so those sort of debates for us as we work in the way that we work as the Equal Education Law Centre have been really present for us. I'm conscious about time. And so I'm just going to try to pick up other stuff that I wanted to chat about with you and about what we're thinking. And what we've also had to think about as lawyers, and what we think that people should be thinking, is the reality is with the profession, with these notions of what the profession is, comes power and privilege. Mm-hmm. And we've had to grapple with, and we think in thinking about the diversion, the way activism and the law come together, is thinking about the privilege and the power which comes with being a lawyer. And how we as lawyers who choose to bring about social change use the power that we know that we accrue simply by the profession that we have. An example of that, for example, would be that in getting dressed this morning, I wondered whether or not I'd come formally and come as a lawyer, or whether in fact I would put on one of our movement shirts which have protecting the right to protest, and I changed about 2 times because I wondered about who I wanted to be and what it meant to be an activist lawyer, and if in fact I betrayed the movement and betrayed the room by yielding the power of a suit. So we've understood that. We'll have equalizers, have a protest, and have debates amongst our lawyers where some lawyers say, well, actually, we must use our power and arrive at the suit so that the police who destabilize the protest knows that the movement has power. And then you'll have a lawyer like me who says, well, that power shouldn't exist in the first place, and so I will go with my shirt and then tell them that I'm a lawyer whilst wearing my shirt and whilst, toy-toying and dancing around with them. And so we've had these vibrant debates, about what does that mean. And so it's about also, I'm just throwing things for us to think about, Tarun. I hope you'll respond, and Shaveen, and you'll say what you think. But it's also about thinking about what does that power and privilege mean in the convergence, or the way the two come together, law and activism, to try and reach or bring about social change. The last thing I just wanted to share in us thinking around these questions is looking at the history of South Africa and the history of lawyering in South Africa, where really the fight for our constitution, which a lot of you will study in your law career, and we're told how it's the most transformative constitution. That fight was fought by activist lawyers who realized that, the idea of lawfare, the idea that something had to give, and the idea that working within the confines of just the rule of law and using just the tools which the profession gave us would bring about change, but would bring about change at the edges of social change. And that in order to be at the center and or to help galvanize the grassroots, that something else, that one needed to co-opt other tools. And so you had, for example, the founder of the Equal Education Law Centre, who was Arthur Chaskelson, and who also was quite a prominent lawyer and also was part of the Rivonia trial. You had those sort of lawyers form what was our first public interest litigation organization, which is the Legal Resources Centre in South Africa, which has brought and born more public interest litigation organizations. We don't use just the courts. We use protest. We use creating popular material. We write op-eds criticizing and agitating around the things that bother us. And the idea is that in using and co-opting all of those tools, and in fact being an activist first and foremost before one is a lawyer, that in fact then you are then a social change agent. I understand, though, that some will debate that and say perhaps you should be at the edges and not at the center. But in fact, for us, we believe that this is the way things should be. I suppose in just summarizing so that I end off on who we are and what we do. In South Africa, for example, there is a court judgment which is hailed as one of our first. I think you were part of the judgment, but it's the Grootboom judgment, which was hailed as one of our first socioeconomic rights cases and very progressive, and we all studied in university. And I remember when I started practicing and I found out that Ms. Grootboom, who I got told got a house, and this was progressive, never got her house. And that a lot of the changes which needed to happen didn't happen. And a lot of people have spoken about that the reason that didn't happen is because some of the reasons, not the only reason, but some of the reasons was because the social change and the jurisprudence and the judgment came without the sort of grassroots swell and a grassroots to hold the sort of judgment that you have. And a sort of a failure by ourselves as lawyers to think around what does it mean to be a lawyer who seeks social change? Do I seek a judgment? Do I have a grassroots community who can monitor that judgment and hold government to account? Who is going to make sure that people even understand that judgment? Have I built the power of the law in the work that I do? or have I built the power of the law in order to build the power of people? And so that's my sharing, and I guess I'll share a little bit more about our work as we go, but that was just what I wanted to offer to sort of agitate and think around our idea of the law and activism. And so I suppose then, as the Equal Education Law Centre, my answer to the question about can the law and activism go together is really about what sort of lawyer one seeks to be, what sort of change one seeks to be, and how sustainable can that change be in sort of dismantling structural inequalities. And I would suggest that in using sort of movement lawyering, in centering your lawyering more around communities and grassroots, real social change is actually gained, and not just jurisprudential sort of changes and wins. Thank you.
Thanks, Nicole, for really vibrant and engaging, thoughtful contribution about debates which we've actually been having here in the Bonavero as well. So now we're going to turn to Shamim for your contribution. Shamim.
Thank you so much. And it's a great pleasure to be joining you all today, albeit online. So the Public Law Project, or PLP, is a national legal charity. For over 30 years, we have represented and supported marginalised individuals and communities when they have been affected by unlawful state decision-making. Our vision is, simply put, a world in which the state acts fairly and lawfully. Before joining PLP, I worked in government, developing policy and legislation, working with government lawyers. After that, I spent the best part of a decade in the city, where I qualified as a solicitor advocate in a leading public law team, albeit I also dabbled in civil law as well. I then helped set up a new charity called the Black Equity Organisation and led its research, litigation and policy work. What my experience has made abundantly clear to me is that the law is a concept that is moulded by many actors: parliamentarians, solicitors, barristers, judges, researchers, policymakers and public body decision makers, campaigners and protesters, the media, claimants, defendants, interveners, interested parties, parties that can be human or sometimes requiring more imagination, such as corporations or other artificial entities. So to answer this question that we're thinking about today during this roundtable, are law and activism incompatible or mutually reinforcing? I want to be specific. I will be looking at the law through my prism, so as a solicitor and in particular as a litigator. As we all know, the topic of this roundtable is particularly pertinent in context of UK politics in the last few years. Lawyers representing those most vulnerable have been vilified. In particular, they have been accused of so-called activism. I've noticed some friends and colleagues react emotionally to that term, a response that is understandable, given some lawyers were physically threatened and attacked after those in power attached irresponsible rhetoric to the term activist lawyers. However, being completely honest, I personally have been quite confused by the whole debate. It seems like a distraction. My clients have included individuals, charities, public bodies, and corporations, each testing the limits of the law, whether in relation to medicine, energy markets, transportation, international banking, the advancement in technology, and yes, human rights and discrimination law. But it is only when working with the most vulnerable and marginalized to challenge power, specifically what we considered to be unlawful exercise of power by the state, did this term activist lawyer seem to apply to me. No one has ever accused me of being an activist when I was working for corporate clients who were also working hard to shift power in their direction through the courts, usually with the political aim being deregulation. But my level of enthusiasm and commitment, strategy and tactics weren't dissimilar to those applied to cases on behalf of vulnerable clients. We often tried to win the case in the courtroom and on the court steps, the legal and moral arguments. That's what brings about change and embeds it. So in preparation for this talk, similar to I imagine others as well, to move away from the rhetoric and the noise, I started looking at definitions and I sought counsel from Professor Google. And so looked up what the word activism actually means. It is the policy or action of using vigorous campaigning to bring about political or social change. campaigning means to work in an organised and active way towards a particular goal, typically a political or social one. As a solicitor, it is my duty to work in the best interests of my client. I do this tenaciously and unabashedly. When working on the most cutting-edge legal work for clients in high-stakes circumstances, I am required to work in this way. Otherwise, I feel it would be an abrogation of my responsibilities to work in their best interests, my Hippocratic oath, so to speak. Therefore, I can see how there is a synergy between the definition of activism and my duty to act in the best interest of my clients. They are mutually reinforcing. But if we are using it, the term activism, it should apply to litigators in all contexts in which they work, not only when they are advocating for the most marginalised. More importantly, from my point of view, though, what does it matter who we, lawyers, are? I do not know what the government's motives were in using terms like activist lawyers, activist judges. Activist civil servants was the most recent one, which really made me laugh. But joking aside, it is more than disappointing and unbecoming. It is irresponsible of our government to stoke the flames. But it is also not surprising. Lawyers who facilitate the most vulnerable in society to hold the powerful to account can't expect those in power to love us for what we do, though of course a bit of courtesy and respect for the profession wouldn't go amiss. We all want to live in a world where the state respects the rule of law, but the universal reality is that all states are run by people. People can be brilliant, fair and kind. People can also be fallible. They can be ambitious and fail to consistently do what it takes to strengthen society in all that they do. What we lawyers must remember is that this rhetoric is a distraction and it must be called out as such, and then we should move on swiftly. It is a distraction from the real work to ensure that justice is available to all, otherwise it is available to no one. We must centre not ourselves and what adjective should be attached to us. Our job is to centre our clients and their stories. By presenting their reality and their context to actors involved in shaping the law, we can ensure that the law is just. I anticipate that the next flashpoint that will cause this rhetoric to flare up again is the illegal migration bill. In our view, this bill is one of the most damaging pursued by a British government in living memory. It locks the door to Britain for most refugees, those most vulnerable in the world. And the way in which the UK government is pursuing it at breakneck speed, with no public consultation, and without even being able to declare that the bill is incompatible with human rights, is hugely concerning and not demonstrable of a confident state. This bill will likely come to a head in the courts, and given the strength of feeling, no doubt, some in government will accuse lawyers of being activists when supporting their clients in challenging the most egregious aspects of it. But this is a bill where the government, with its lawyers, are testing the limits of international agreements, including the human rights framework. Of course, it is right that in response, non-government lawyers, together with their clients, ensure that the courts determine whether those limits have been breached. So to conclude, within the paradigm that I described earlier of all of the actors involved in shaping the law, I have the privilege of being a lawyer. And yes, I specifically am a lawyer who is proud to lead a national organisation that represents the interests of those most disadvantaged in society. At the Public Law Project, we get to test the limits of the law too, respectfully, but also vigorously and in an organised and active way.
Thanks very much, Shameen. Very interesting to hear the kind of different registers coming from different parts of the world. Taran, over to you.
Thanks very much. So I'm not a lawyer, I'm a legal scholar. And therefore I'll mostly talk about activism in the academy. I should perhaps locate my own myself biographically first in relation to activism. I think my political awakening happened as an undergraduate student when I interned with a union of farmers and laborers in one of the most marginalized districts in India, in rural Rajasthan, and worked with this amazing group, which is doing fantastic things. And I remember speaking to its leader, founder, although she hates being called the leader, Aruna Roy, who was making chapatis for us on a wood stove in a mud hut. She asked, what do you want to do? And I said, I'm thinking about the academy as an option. And she thoughtfully, mulled over it for a moment and then said, democracy needs its lawyers, but make sure we understand what you write. And that lesson has stuck. What she did not say was you have to become us. But anyway, so in some ways what I'm going to talk about is an elaboration of some of those early lessons. So here's how I understand activism, and I think the two previous speakers have given a very good account of it. I'll just put some emphasis on certain aspects. So obviously, I think it is about trying to make material, political, social, cultural change in the world. But what is often missed out in the discussions, and I think Shamim has already alluded to it, is that two can play this game and two do play this game. So activism, although a label stuck usually on what we might think of as progressive politics, is rife on the other side, as it were, right? And right-wing activism, for example, including in the academy, is as prevalent. You talked about activism of corporates trying to avoid taxes, right? So I think as a term, it's neutral in terms of its moral goals, its moral objectives. It can serve many masters. But, while that, one way to think about it is, why are you only calling left-wing lawyers activists? What about all the right-wing lawyers? Were the lawyers who took Dobbs to court, for example, in the US, were they activists or not? A different way to think about it, and perhaps give us some reasons to pause and to think about it, is that two can play this game. So all the constraints that we push against to seek progressive goals are things that constrain not just progressive politics, but also reactionary politics. India, the jurisdiction I know best, saw the courts doing away with judicial discipline, where legal formalism, the rule of law, became bad words because of progressive activism by lawyers in the 80s, created a court which has no self-restraint, which has no discipline, but one whose progressive politics has now been largely replaced by a very reactionary politics. An undisciplined court that went on to order the government, that held a judicial process before deporting so-called illegal migrants to be unconstitutional, and replaced it with an executive process without any judicial discipline and flying in the face of the rule of law. We have a government today that uses lawfare to secure extremely authoritarian goals. So that's the first caution that I want to start with, is that just as activism is morally inert, all the tools that are being deployed on one side create precedents for the other side. Now, maybe we don't care about it, right? Maybe one response may be, well, the system is broken anyway, and I'll just do what I can do to further progressive goals when I can, right? But a different response, and I believe a response we should have, is we have to pit the price of justice in the individual case alongside the price of preserving systemic virtues in a system that is good enough, basically. So I would make a distinction between thoroughly unjust, corrupt, vile systems like apartheid South Africa, where I have no worries, no qualms about a no-holds-barred approach to the law and seeing it as a thoroughly instrumental tool. And a system that is basically good, in need of improvement, absolutely, but a system whose fundamentals are sound, and therefore the need for preserving the system's fundamentals should be something that needs to be factored in, not necessarily always outweighing the costs in the individual case, but it needs to be factored in. Am I damaging the system? Or am I improving it, making it even better than it needs to be? Right? So I'm not here to tell you whether your systems that you work in are good or bad, but I just want to say that that having seen a system dismantled from up close in India by well-meaning progressives and liberals, and I think we're paying the price for it now. It's a cautionary tale that good intentions can completely destroy the system's ability to do even basic good. So a couple of other unrelated thoughts. Just as I think activism is morally inert, I think, law itself in the individual case is morally inert in that it usually helps the powerful, but it can be used by the vulnerable. And I don't even think of it as activism. I just think of it as basic decency to try to use the law when you can to help the most vulnerable. And I just like that is just something that all individuals have a basic moral duty to do is to help the most vulnerable in whatever institution you are, whatever institution setting you are in, whether you're a lawyer or a scholar, etc. So I just don't think of that as activism, or if it is activism, that's just not something to disagree with at all. I think the difficult territory, and you both obviously thought about this deeply, right? But the difficult territory is when the good intentions are not matched by the homework. So what I think of who is the good activist in my imagination, Aruna Roy is always sort of the model that I think of as a good activist, right? But so I'm drawing from a very small sample size, but it's a very good sample size, good sample, right? So who is a good activist? A good activist, A, is committed to the right sort of values, good moral values, not the bad values. But an activist who starts her activism from day one in that participatory, consultative manner, without any preconceptions, without coming to the table knowing what you want. Because if you want to do good to others and know what it is to do good and what is the good you want to achieve, you already lost the game in progressive political terms. Right? Even the agenda setting, the means of the process, the means of the campaign, all of that has to be done in consultation, in participation, as a group, as a collective, and not individually. And the activist needs vast strategic wisdom, an ability to be nimble, to make changes in strategies very quickly, because the political landscape changes very, very quickly. An activist has to make all things considered judgment. The activist cannot, I think a good activist cannot be single-minded in the pursuit of one value or one idea, whatever the cost there may be to other things that we also should worry about. And an activist must be able to understand that sometimes legal defeats are political victories, and sometimes legal wins are political defeats. Right? An activist has to know that there are huge risks involved in trans-border activism, right? Especially if you're sitting in the global north and trying to do good in the global south. Right? What has worked for your context may not work in other contexts. Right? So if these are activist virtues, then there's a difference between a lawyer who is embedded in a movement, who is an activist lawyer, think like the two of you, or at least certainly you, who understands these things, and a lawyer sitting in the national capital without the benefit of the campaign, without the benefit of having that essential grassroots democratic pedigree, but with the powerful tool of the law and therefore the capacity to do much harm without meaning to. So plenty of examples, I'll not name names here, but plenty of examples from India where, Delhi lawyers, meaning well, have done irreparable laws, including, getting people executed while trying to save them, right? Just by failing to understand what good activism requires, failing to consult, not knowing when is the right time to bring a case and when is the right time to not bring a case, right? And let others do this job, right? So that's all I will say about practice. But just a few words on my vocation, which is scholarship and academia, and then I'll stop, which is that, at least lawyers are engaged in practice like activists, right? And at least they have an eye to thinking about what might work in practice and what not. People like me, good scholars are not trained, and our systems are not designed to make practical interventions. Scholarship is designed for truth seeking. Scholarship gives me the time to think about one tiny issue for a year or 2 or 5 that activists and lawyers have to judge overnight. Sometimes in a matter of hours, you have to take course. And that is the case because I have that luxury of time and protection from external influence, because my profession teaches me to go deep, put blinkers on, bracket everything else, and to explain and understand that one thing that we need better understanding of. And when I forget my own limitations, I may be a very good academic in understanding and explaining ideas. But when I forget my limitations and when I believe that because I have seen a small part of the truth, that I also know what needs to be done in the world, and I go out in the world and try to make change with the benefit of my own privileged position, I think I'm an even more dangerous person than the lawyer. So I think as an academic, I see my role as engaging with civil society, with movements, with lawyers, with translating my scholarship when asked for expert advice, saying what I know with all the caveats involved, including that I'm not making all things considered practical judgments. I'm trying to understand, for example, the value of freedom of expression, but sometimes maybe that's not what you need. Maybe freedom of expression should give way to other values like equality, which I may not have studied and therefore may not be passionate about. So I think there is a role, as Aruna told me, for scholars in a democracy, but we have to come to that role with the humility of knowing that we don't know everything and that our enterprise is primarily theoretical. We ought to lend it to others and to explain what we find to others and engage in the world. But the skills of activism are very different. The time horizons for activists are very different. And the audiences of activists are very different from those of a scholar. So I think that is where I'll stop. Thank you.
Thanks, Tarun. So I think that's, again, a very interesting example of how where we come from and what our own experience is determines a lot of how we think about these problems. And I do have a sense from listening to the 3 presentations that in fact there's a lot of common ground here, even if at one level there sounds like there isn't. And that common ground is a recognition that we live in societies in which we want to pursue, I think all 3 speakers want to pursue a more equal, more inclusive, more just and more fair society. So there's a sort of normative agreement there, but there's also a recognition that there are people who have different sorts of values and political projects. The one thing I wanted to put on the table is that I think all 3 speakers spoke about a bit, but is that I think that the way in which we do law is one of law's moral values is how we do it. So doing law with integrity doing law in ways which are honest and accepting that that everybody ought to have a fair opportunity to be heard in a proceeding, etc. Thinking about how we do law is very important. And I think one of the things that Taran is concerned about is when, as activists, we think we might cut corners or we might do law in an instrumental way, which might damage actually the legal system. And I think his argument is that when you do that in a woefully evil system, then that may be okay. And that's a debate that, that's a very sort of 1980 South African debate. But when you do it in a democratic system, it's something one needs to be cautious about. And I think there is a tendency at times for people to get a bit instrumentalist. So I think that's another way of thinking about these conversations. But I'd like now to open it to the floor. There are lots of people in the room with lots of experience of thinking about these things and lots of people online. Please just put up your hands online if you'd like to contribute. I'm just going to look around the room. Please